Today, the Chief Justice of the Alabama Supreme Court, Roy Moore, issued a administrative order. It's more in the form of a letter in his capacity as the head of the judicial department of the state, and not as an order from the Supreme Court of Alabama. Now, that's an interesting distinction, but basically, administrative orders come out to the lower courts to tell them basically how to handle certain procedural matters in their office or certain ministerial things that they carry out. In this situation, the Chief Justice's administrative order directed probate judges across the state to stop issuing marriage licenses to same-sex couples. And in his rationale, he said that the Supreme Court's decision this summer in Obergefell v. Hodges, which said that there was a right, constitutional right, for same-sex couples to marry, does not actually apply in Alabama, that it only applied in the Sixth Circuit Court of Appeals jurisdiction, which were states generally in the Midwest. That is an interesting argument that probably will not survive review by either one of the federal district courts or one of the federal appellate courts. There is a federal court in Alabama out of the Southern District in Mobile where the judge in that case already issued an injunction that prohibited probate judges from denying marriage licenses to same-sex couples. That decision came out before the Supreme Court issued its opinion, but of course the Supreme Court opinion in Obergefell reaffirmed the rationale that was used in the Alabama federal court order. So this exercise by the Chief Justice today is in the news and will no doubt create a lot of confusion, and you can probably expect that most probate judges will continue to issue the licenses because they are part of the federal lawsuit in the Southern District of Alabama, and there has already been an injunction entered against them that would prohibit them from denying licenses to same-sex couples. There is something referenced in the Chief Justice's order about a pending decision from the Alabama Supreme Court involving a case filed by the Alabama Policy Institute, which sought to basically stop the issuance of same-sex marriage licenses. That case has kind of been sitting out in limbo. There was a temporary order issued by the Supreme Court where Chief Justice Moore did not participate. However, there has not been a final resolution of that case, the API case, the initials of the Alabama Policy Institute, one of the petitioners in that case. That's what it's known by. And his letter today, or his administrative order today, references that that case is still under consideration, presumably by the other members of the Alabama Supreme Court. So we don't know what the Alabama Supreme Court will do with that case. They could issue an order which would certainly nullify the Chief Justice's administrative order today. But likely what is going to happen is there will be action in the federal district court in Alabama if any probate judge refuses to issue same-sex marriage licenses in line with the U.S. Supreme Court decision this summer. It's important to remember that though reasonable people can agree or disagree whether something like this is something that they personally are in favor of, as lawyers, it's hard to understand how the Supreme Court of the United States, in its decision in Obergefell, was not crystal clear, and anyone who's been to law school, even to take a first-year constitutional law course will tell you that in the end, the rulings of the United States Supreme Court are the law of the land, and federal rulings as to what is constitutional or not trump any state court's ruling on what is constitutional or not. So in the end, the United States Supreme Court has the final say. And, there was a former justice who famously said that the Supreme Court, the U.S. Supreme Court, is not final because they're always right. They are right because they are always final. And that's an interesting turn of phrase that Justice Jackson used many years ago, but I think it explains a little bit that even if you disagree with the United States Supreme Court, in our system, they have the final say as to what the Constitution means. And the only way that that could be changed is by amending the Constitution, and there have been no serious efforts going anywhere to amend the Constitution to address the issue of marriage. There were state constitutional amendments, but there's never been any serious positive movement towards a federal constitutional amendment. So, this will be in the news a little bit more, and there'll probably be a flurry of court actions in different places across Alabama. But I hope that this at least explains a little bit about what's going on and what is likely to happen.